Everyone. My name is Jen Lowe, and I am a counselor in the state of Michigan and the state of North Carolina. And this presentation is going to just be a little bit about what you need to know about HIPAA and protected health information. I should be able to see my screen here. There we go. All right, so HIPAA and protected health information. All right, here's a fun little meme from a website called Person Centered Tech. Person Centered Tech was founded by Roy Higgins, and it's a company that helps counselors and therapists learn about not just HIPAA and protected health information, but about any sort of technology item that we need to know. So they have this little meme on their website. I refuse to move away until all devices are locked away. For example, if we are at our office, we're seeing clients, we're in between clients, we need to run to the restroom real quick, right? Locking our laptop or putting on a lock screen, locking our door, grabbing our keys, and going to the bathroom. We don't just run to the restroom and leave, notes out on our desk and our office door open. So, like this little seal. All right, this is just a funny little joke because you'll see this misspelled a lot with hippo, like with two P's. So there's a difference between a hippo and HIPAA. HIPAA is only with one P, two A's. It stands for the Health Insurance Portability and Accountability Act, and this will be information that you'll be quizzed on later. All right. We do not just want to hope for the best. We also want to mitigate the risks. So HIPAA asks us to look at what are the risks? What are the risks for our clients' protected health information? Another funny little meme to get us started. When a client's parent or spouse calls to confirm an appointment schedule. Huh? Now, we probably wouldn't say that. We would just say, hey, due to privacy, I cannot confirm or deny that I know anyone, especially when they're over the age of 18, right? If they're over the age of 18, we would need a release of information before we even told someone, oh, they're scheduled Thursdays at noon. One of the things that Person-Centered Tech teaches on their website, and they do there's lots of free resources, there's funny little memes, there's paid trainings you can take. That using mobile data is better than using someone else's Wi-Fi. We want you to have a secure connection when communicating with clients, either a telehealth session or just simply like emails or communications, right? We'll talk about emails later on. This is going to be just a small little mini lecture for my counseling students to learn about HIPAA and protected health information. We are going to do some more activities, assignments. We're going to do a deep dive. It's just a brief little overview here. All right. I want you to be able to sleep well at night, right? I want you to be able to lay down, relax, know that your information is secure and not have worries. More than you, though, this isn't just about you. This is about our clients. We want our clients' information to be secure. In the counseling relationship, trust is really, really important, right? Counselor-client relationships are only effective when there is trust. Trust can only happen when clients believe that communications with their counselor will be protected by confidentiality, privilege, and privacy. This is from a textbook, Counselor in Law by Wheeler and Bertram. Great book. And there are other things that are crucial to the therapeutic relationship as well, right? We're just going to focus on the protected health information and the privacy today. So we're going to do a little deep dive. I don't know if it's a deep dive. We're going to do a little brief overview about confidentiality, privilege, and privacy. All right, confidentiality is an ethical duty to protect private communications. This is talked extensively about in the ACA Code of Ethics. It is part of your informed consent process, which is required in the ACA Code of Ethics. And I need all counselors to put it in your professional disclosure statements. There needs to be some information about clients about confidentiality. Here's a definition. Confidentiality is your ethical duty to protect private client information and communication. This is not just confidentiality within your counseling sessions when people are in your office or telehealth. This is also their emails, their texts, their voicemails, their communications, your notes that are in your office. So that was confidentiality. Next, we're going to do privileged communication. Privileged communication is a legal term. Now, I realize I'm going to have counseling students from all of the 50 states here. So most states, so please look up the laws in your particular states. Most states give counselors the same legal protection under privileged communication that attorney clients have, doctor patients have. But you might want to just verify the laws in your state, right? Privileged communication protects the communication between two parties, attorney client, doctor patient, counselor client. When we talk about privileged communication, the privilege is actually not yours. You as a counselor are not the one who has privilege, right? Your client has privilege. Privilege belongs to the client. However, the counselor is in charge of upholding that privilege, right? When we talk about privileged communication, the communication is made in confidence, right? So that client, that patient believed that when they told you information, that it was privileged communication. Privileged communication, here's a quick definition. You ready? Protection of confidential communication between two parties in a legal setting. There's our big difference so far. You ready? Confidentiality is something we talk about in counseling, right? It's part of our ACA Code of Ethics. It's an ethical term. Privileged communication is more of a legal term. Okay? However, this does come into play, and we'll do some deep dives into some case studies and stuff in class. But this does come into play because sometimes we, as counselors, are in legal settings, right? Exceptions. All right, here are some exceptions to privileged communication. This is not an extensive list. Brief overview here, people. A danger to self or others, malpractice, and claims of insanity. So if you have a client who's a danger to self or others, that is an exception to privileged communication. I loved learning about this in my doctoral program. Because I used to wonder, I used to think about it. Sometimes we'll see famous court trials on TV, and counselors will be testifying in the court trial. And say, for instance, like someone who's on trial for committing like a school shooting, and their counselor is testifying, and I think, surely those people didn't sign a release of information, right? Like they wouldn't want like that as part of their defense. Um, But yeah, danger to self or others. Malpractice. So if someone is pursuing litigation against you as a counselor and they are claiming a malpractice claim against you, you are allowed to defend yourself in a court of law. If they have initiated a claim against you, you and your attorney will go through the notes and you are allowed to defend yourself. And you are allowed to talk about some of those things that you all discussed in session, diagnosis, things like that, communication. If they say, you didn't communicate with them, but you did, and you have an email, you can bring that as proof, right? Emails, just to let you know, need to be HIPAA secure. So we'll talk more about that in class. And then claims of insanity when someone is on trial and they would like to plead insanity, the court can look into their previous counseling records, psychiatry records, medical records, etc. All right, last one is called privacy. Privacy is the basic right of a person to be left alone and to control his or her information. This term nowadays is used interchangeably with confidentiality. However, you'll notice the ACA Code of Ethics talks more about, they use the term confidentiality than privacy, but out in the world, you'll hear it referred to interchangeably. Okay? Here's the definition from Wheeler and Bertram. The basic right of a human being to be left alone and be in control of their personal information. All right, a little brief overview of HIPAA. I have a reference here for the U.S. Department of Health and Human Services, their website. So HIPAA was passed in 1996. It stands for the Health Insurance Portability and Accountability Act. Prior to HIPAA, no generally accepted set of security standards or general requirements for protecting health information existed in our healthcare industry. So a lot of times when we go to doctors and dentists and counselors, they make us sign the HIPAA statement, right? You as a counselor should make your clients sign one too. It's part of your informed consent documents. When we just sign it, and they're like, would you like a copy of it? And we just sort of sign it. And we're like, oh my gosh, this is so stupid. We needed it. We did need to have a set of standards in our country saying that providers, not just mental health providers, medical providers, dental providers, needed to try to keep their clients' and patients' information secure, right? It has two parts, okay? It has the HIPAA privacy rule and the HIPAA security rule. Okay, they're a little bit different here. The privacy rule is national standards for the protection of certain health information. Okay. The security rule is national security standards for protecting electronic information. So when we think and talk in class later about your emails, about an electronic health record system, about your cell phones, how you're communicating with clients via technology, that security rule is going to apply. And then here are my references. Thank you all so much. We're going to do a deep dive into this more in class later. Thank you so much.